Defense has pointed out discrepancies in statements made by Zandile Khumalo to the police. It's now expected to apply to call Kelly Khumalo to the stand. This after the state indicated they won't be calling Kelly Khumalo. But to unpack this further, we're joined by legal expert Melusi Xulu. Melusi, good morning to you and thank you so much for joining us. Why would the state not want or intend to have Kelly Khumalo as a person of interest in this case in the first place? Good morning.
Good morning, Cindy, and good morning to the viewers at home. The main reason why a prosecutor would not want to call a state witness who has written a statement will be because of two things. One, it will be because the state witness is not going to take the case of the state any further, meaning the prosecutor will believe that this witness will not add anything. The witnesses that he has or that he has called are enough to say the case can be proven beyond reasonable doubt, which is the duty of the state. But the second reason will be that the state might feel that as much as the state witness can be important for the state, it could be that the contradictions or the issues that may come up in his or her testimony, in this case, Kelly Khumalo, they might affect the case of the state in a negative way. For example, if there are contradictions which are major, compared to the other witnesses, that might be one of the reasons that he might say no, they don't think it will assist the case of the state to call that witness for the state.
And the strength of the defense's argument to have Kelly Khumalo in the witness box, is there the prospects of success, or maybe even speak us through what the process is likely to be? Will she be subpoenaed? Can she decline to appear before the court? What are the options?
Okay, if we go to Procedure Act, there's a couple of section 179. It states that the state or the defense can call or can ask for a witness to be subpoenaed, and even the court can ask that if it's for interest of justice that a witness can be called to come and testify. So there is that option, and if you obviously don't come as you are called for the courts to come and testify, a warrant can be issued. But I think for now, let's just see what will happen instead of maybe creating scenarios, but there are those possibilities.
All right, but maybe what we can talk about, if the defense intends to apply for Kelly Khumalo to be in the witness box, how long do they have? Is there a framework within which they need to work through?
There's no framework at all. They can wait for the state to finish their case and finish calling all their witnesses. Then they can bring an application and ask the court to subpoena any witness that they feel is needed for the interest of justice. And then the application can be processed and the witness can come and testify. So there's no framework, but for now, it's still the state's case. They have to call all the witnesses that they feel they must call or they believe they must call. Then once they are finished, we can look at those possibilities.
And just your analysis around the proceedings so far and whether the state's case had been bolstered with the state witness Zandile Khumalo and her even losing her composure at some point because of the pressure or the line of questioning. Do you think that the state's case is solid at this stage?
Whenever I'm called to discuss this case, maybe I'm going to be repeating this a bit. But Cindy, it's very strange to have a case where there are two pockets. I think if you start with that, it brings you an idea that the state's case is not really sure where they are going with this case. But if we analyze her testimony, she's not a witness who gives you that confidence. She loses her composure, as you say. But it's not the only evidence that the state is bringing. So it's still too early to say definitely the case of the state is not a strong case, but it has not started on the right footing, so to speak.
The discrepancy is also the fact that we've all along known that there were two intruders, and yet there are 5 suspects that are facing the murder charge. That in itself, with the state witness Zandile Khumalo not really being able to convincingly identify who their intruders are.
Yes, she kept saying is accused to Mr. Dance, if I'm not mistaken. And my issue with that for now, is that her testimony is based on what we call a dog identification, which means the witness can say, I cannot remember the person. But when he comes on, when she comes to testify, or he comes to testify, he will say it is that witness on the dog, it is that accused on the accused dog. So there's case law that says we must take dog identification with extreme caution, unless it is sourced in independent identification, preceding identification. So there must be something more, for you to say, I remember him because he was tall and I can see his face. It's not enough. So I think it must be taken with circumspection when she says she's identifying him because she's seeing on the dog.
If memory serves, just before we let you go, Melusi, there was also a mistaken identity shortly after the events of the fateful day. Either a neighbor or somebody who's known in the neighborhood who was arrested and only to be found to have not been involved. What is the likelihood that these 5 suspects in themselves could have been wrongfully arrested?
Cindy, I think that's one thing I've seen that is not being discussed more in the mainstream media. And it's very important. The name is Zamogo Shembata. He is a neighbor who watched the X6 that belonged to Mr. Meyiwa, and he's a known neighbor by the Khumalos, if I remember correctly. So even if you see the Netflix documentary, you can see that it's someone that they knew. So if people in the house, now let's look at this logically without discussing the legalities too much. If people in the house point out someone who's a neighbor, and then that person is released, what does it tell you about the people that are inside the house? That is why the docket 375 of 19 is very interesting to note. And I think Advocate Xulu did bring it across in that, the people who are testifying are also accused in the sense that they are suspect, not accused, in the sense that they must speak the truth. So here's the thing that we must remember when it comes to criminal law. The state must prove its case beyond reasonable doubt. And if there's some doubt, that benefit must be given to the accused. But as I said, it's still early, but it has not started on the right foot.
All right, much appreciated for your insights there. Melusi, thank you so much for your time. We're speaking to Melusi Xulu. He's a legal expert reacting to the proceedings in the Senzo Meyiwa murder trial currently underway at the Gauteng North High Court. And we have Manqoba Mchunu, eNCA reporter, who will give us an update. Court is expected to resume at 10 o'clock this morning.